So what is the waiting period, or the cooling off period as we call it, to get a divorce in California? You cannot be divorced in California until 6 months and 1 day pass from the date the other party is served with your petition for divorce. So you need to, there's no way you can get divorced before that, and there's a reason for that. California has a cooling off period, and they know that spouses do consider reconciliation. The public policy in the state of California favors marriage, and it favors people working to save their marriage. And the fact is, I've worked with many people who actually, in the end, reconcile. And so that you cannot think that when you are determined to file for divorce, and if you do believe you should file, you should file. But there is a cooling off period, and many people put their marriages back together. So how long does it take, if you've got a contested divorce, how long does it take to finalize your divorce in California? Here's the thing. If you go to the regular public court system, you are dealing with a bureaucracy. It's a very crowded system, and you're paying a good amount of money for your attorney to show up in court multiple times to get your case done. It's pretty clear in California, if you have a case with children and assets and it's contested, you will be in the litigation process for at least a year. And that's a pretty quick case. I've seen cases go much longer than that. You have to really be on top of it to get your divorce fully done in a year. Now, there's another thing in terms of your divorce. What if you need to be divorced for whatever reason? Maybe you have a religious reason that makes you feel like you cannot date until your marital status is terminated. We can get your marital status terminated by the 6-month date if you want. That's a special process, but we can get that done. It will take time beyond that most of the time to divide your property and to get the other things worked out. But we can get your divorce within 6 months, and that's in terms of getting your marital status terminated. I always tell my clients, if you think divorce is imminent, if you think it's unavoidable, you need to be the one to file your petition first. It's super important, because the one who files the petition first, of course, is the petitioner. In your family law trial, which is the end hearing, it's the final hearing in the case, where the courts spend a lot of time, the petitioner gets to put their case on first. And that's a huge benefit, because you get to tell your side of the story first. You get to present your facts first. And I remember I had a case one time where I represented the petitioner. We didn't even put our entire case on. We put about 2/3 of our case on, and the judge, who was obviously very busy, called both me and the other attorney in the hallway, and he looked at the other attorney who had not even said anything yet in terms of putting on his own case. He looked at the other attorney and says, "What do you have that will refute all of this?" And so the judge in that case, just by hearing 2/3 of my case, was already convinced that we had presented a good case, and he didn't want to waste a lot more time. So the respondent often has the difficult job of having this uphill battle where the other side has already presented their case, and now the respondent has to present their case, and they get less time, and they've already got a judge who may be leaning toward the petitioner or convinced by the first party who put on their case. So super important, if you can, to file your case first. Be the one to file for divorce first. Be the petitioner. So how can these cases be delayed? How can they take a year to 2 years? One of the real delays is just the fact that a court is a bureaucracy, and you're going to go to court at the beginning of your case for various things, and you will be one of 10 people, maybe 10 cases the judge will have to deal with in a 3-hour period. So the judge in the beginning stages of the case is going to do very little but triage your case. And you're going to get a little bit of attention from the judge, but not very much. And so that alone, and then invariably there are what we call continuances, delays, where the other attorney is unavailable, or maybe your attorney is unavailable, just various things. And then there's a process of discovery, which can be quite lengthy. If you have a business, one or more businesses, the court will most likely have a forensic accountant be the court's expert. And that forensic accountant is going to value the businesses. It's going to do a marital balance sheet, figure out how all these assets can be divided once they're fairly valued, and also evaluate the income available for support. So those are three things the forensic accountant may do. And that forensic accountant is going to be in a process for quite a while of getting documents. These forensic accountants, they give you a huge list of documents you need to provide. And it takes oftentimes months and months just for the forensic accountant to get the documents. It's an expensive process. And if you have a forensic accountant appointed in your case, which is quite normal, again, if you have a business, that forensic accountant, that process is probably going to take anywhere from 6 months to a year just to get the accountants ready. And then after that, you can finish your trial preparations and go to trial. But these cases where there's high assets, they can easily take a year or two. Now, having said that, there is a better way to deal with your high asset case or a high value case than going to the public court system. So there is a better way to handle your case. And what we do often is we hire a private judge, a private neutral, who we don't go to the public courthouse. We go to a building, an office building, and we mediate the case with a very experienced private judge. This is somebody who probably has been a family law judge and lawyer for over 30 years. And this person who we hire to handle the case can bring the case often to a very good conclusion without all of the hoops the public court system makes you jump through. So it's actually, if you have a high asset case or you're able to afford it, in almost any situation, the private judge is going to make the case more economical. And you're going to go to an office building, it's pleasant, you're going to be in a conference room with your attorney. The other side will be in the conference room with their attorney. You'll have a very experienced, neutral judicial officer going back and forth, the judge going back and forth, meeting with both sides. And I will say 90% of cases can be resolved with a private neutral in a much faster time frame than the public court system. And I will say another thing about that. It's really a paradox because you are paying your legal team a good amount of money to handle your case. And then you're also dealing with inevitable public delays. So that can be very painful financially. You want to get in the process, file your petition first, determine if you can resolve it through a private neutral, and get out. Get out with your dignity, get out with your money. Put your kids through college, not your family law attorney's kids. We can accelerate your case. And in doing that, we will save you considerable amounts of money. And we do that by using a private neutral and bypassing the public court system.